Awfully quiet. Good afternoon. This is the House Judiciary Committee. It is the 5th of April and we're a little after 2:30. We're going to start with a concurrence, a motion to concur. Is the vice chair around?
She was just here and then she just left.
Where is?
That one.
All right, well, then I'm going to read this announcement then before I go to the concurrence calendar. I've been asked to read the following from the Information Technology Office. During the 24 interim, the Information Technology Office will be performing phase 2 of the AV refresh project to upgrade the committee hearing rooms infrastructure. You all will need to make sure that you clear out your desks while you're here in the last few days of session of all of the misused candy bars that you've left there and all of the other things that have probably been sitting there collecting mold for years.
That part's not in the
Oh, okay, I'm sorry. Should really get glasses. So they're going to have to move all of the desks out. So please do make sure that as you are here the last couple of days of the legislative session, when we may not be in here very much, you want to take the time when you can to make sure that you clear out your desks. Thank you very much for that public service announcement. Now, we're going to go to House Bill 814. This is the Juvenile Justice Bill. The House Bill 814 has been returned from the Senate, and I would ask this committee to concur with the Senate amendments. Could I have a second on that motion? Thank you. There's a motion to concur in the Senate amendments. Members of the committee will certainly know that we have spent an enormous amount of time, and rightly, on this issue. We have taken this issue very seriously, and I hope very much that that the steps that we are taking here going forward will help us to put people in place first to do the accountability work that needs to happen in this area of the law, but also to build guardrails around the Juvenile Justice Reform Council's work from 2022, legislation we passed in 22. There are the amendments the Senate added to House Bill 814 include an amendment that takes out theft if it's committed by a person aged 10 to 12 from DJS supervision. So they would not be under DJS supervision if they were between 10 and 12 and were alleged to have committed a theft of a motor vehicle. I'm sorry. You should have the reprints at this point, and the reprint would be on your floor system, I think, at this point. Right. So and I would point you to, really, it starts at about page 30 because there's been so much work that's been done on the bill. In any case, car theft would be a mandatory sins petition. Gun possession cases would remain as a DJS supervision or DJS jurisdiction. However, they would not be eligible for detention. The language that was added by the Senate also, it clarifies that if a police officer asks for a child to be detained and DJS refuses that, DJS has 2 business days to make their intake inquiries and decide what they were going to do with the child or not. There's language added to the bill that requires the forwarding to the state's attorney of all cases where a child fails to complete an informal adjustment, which is basically clarifying current law. The amendment also adds language allowing an intake officer to proceed with an informal adjustment while a state's attorney conducts a preliminary review of the case. In the section related to pre-hearing detention for misdemeanor offenses, the amendment carves out second-degree assault from misdemeanor offenses eligible for pre-hearing detention. So it would carve out second-degree assault from the area that says that if the new crime carries more than 2 years in jail, that would be eligible for pre-hearing detention. The amendment carves out second-degree assault, which carries a maximum penalty of 10 years. It adds language requiring DJS to give notice to the court, the state's attorney, and a child's attorney whenever a child violates the terms of electronic monitoring. It revises the definition of good cause to extend probation to clarify that a child missing court-ordered treatment constitutes good cause to extend probation unless the court finds that the child has substantially completed the treatment program despite the absences. We in the bill initially, and it's still there, said that if there were 2 absences of a program, that people would have judges would have good cause to extend a child's probation. What the amendment says is if they were supposed to go to 16 weeks of a program and they showed up to 14 of them, that would not necessarily be good cause. If they were supposed to go to 4 sessions of a program and they didn't go to 2 of them, that would be a reason to do good cause. But to avoid some of those problems, we added language and negotiated language that requires notice to the court when a child on probation has 2 or more unexcused absences, with the idea being that we'll let the court know so the court can intervene prior to having to extend their probation in the first place. The amendment adds language requiring that the pamphlet provided to crime victims include information on how to file a complaint with DJS. It includes a requirement that GOCAP report on youth diversion programs. The amendment also adds language requiring the Department of Juvenile Services to include programs developed for youth involved with motor vehicle theft. It adds a member to the commission, which would be a representative of the Maryland Consortium on Coordinated Community Supports. And it changes the effective dates, saying that the commission would start on June 1st, 2024, and the bill as a whole would switch from being effective on January 1st, 2025 to November 1st, 2024. So the commission would be able to start earlier. And as I think I've mentioned a couple times, the commission would, I think the governor's office is ready to get to work on the commission just as soon as we pass the bill. Okay, so that is where we are. There's a motion and a second on the motion to concur with the Senate amendments. The vice chair, and then we'll go to other questions in a moment. The vice chair.
So, Mr. Chair, thank you very much for that explanation in this 39-page bill, or actually 62, I says on here, but I double spaced. So anyway, okay. So, can you go over on page what is online on page 33, which talks about a crime of violence. And it states that a crime of violence is a crime involving handguns under certain criminal law sections, but it also, and others, and it also talks about aggravated cruelty to animals. Can you explain, can you answer the question as to whether or not we care more about animals than we do about children with respect to that?
So the part of the bill that you're talking about, just to be clear, if a 10 to 12-year-old commits a crime of violence, that is already under the Department of Juvenile Services jurisdiction. The part of the bill that you're talking about with regard to aggravated animal assault is the most serious form of assault against an animal. And it does not happen often. It happens rarely, but when it does happen, it can be an indicator for other issues that the child may be happening with the child. And so to that end, that is why that is included in there. And it is why it's included under DJS in supervision or jurisdiction.
Just so I'm clear, the ramifications of having a handgun or a firearm, are the ramifications more serious than aggravated cruelty to animals, which is a felony, or? less serious.
Aggravated cruelty to animals is actually not a felony.
Oh, I
It's,
thought I said
I
it
don't
was a
believe
felony.
that it is a felony.
Okay.
I believe it's misdemeanor. And the simple possession of firearms, the simple illegal possession of firearms is also a misdemeanor. And so I think it's difficult to compare. In the case of aggregated animal assault or aggregated cruelty to animals, I believe that again has some indicia of other issues that need to be addressed. In the case of gun possession, that also could lead to more serious issues, but in the negotiations with the Senate, we came to a place where we felt that they should not, at least for a first offense between 10 and 12, see detention, that we should try community alternatives first, and then try, if that doesn't work, then you look at detention going forward.
For those handgun
For the
crimes.
possession of handguns.
And for the possession of handguns only, but what about a crime involving a firearm under the other parts of the public safety article?
So if they're committing a crime with a handgun and they're brandishing it, they're using it in a robbery, that becomes a crime of violence. So that was already covered for people between 10 and 12.
Okay.
Yeah.
Okay, thanks.
All right. I'll go to Delegate Taylor, then I see Kaufman, then I see Pasteur.
Thank you, Mr. Chair. You're my favorite chair.
But
There's no but. We took a lot of time with crafting thoughtful and very thorough legislation with lots of caucuses and lots of discussions. I've really tried since this morning, since I heard about these changes, to ask questions of folks that I thought might be able to help me. I'm just feeling a little stressed about making a decision right now without having had the time to compare the changes. And maybe there's a document out there that says this is how it was when we sent it over and now this is what we have. If that's what we're doing now, then that's fine, but I'm having a hard time following all of it as well. So
if you have questions, go ahead and ask the questions. And if you want to take a couple minutes to formulate those questions, go ahead, and I can, no problem coming back to you. And
sure.
and
Is
taking more of those
there or
questions.
will there be a document that will make?
We can provide you, I can provide, and happy to provide a copy of my Cliff Notes to the amendments that are out there. In fact, can we do that? We'll do that right now.
That might help.
We'll
Thank
provide
you.
that to the committee, and that may help to address some of those concerns.
Thank you.
Delegate Kaufman.
Yes, I have a question, then I would like to make a brief statement if that's okay. What does, Mr. Chair, as you know, I'm not a lawyer, so what does informal adjustment mean, please? And then I have a statement.
Informal adjustment is effectively DJS's method of doing diversion within the DJS system. That is perhaps an oversimplification.
So sending them to ROCA is an example?
Could maybe, although ROCA doesn't deal with as many kids, they deal with some juveniles. They don't deal with as many as other programs.
And then my statement is that, as many of you know, I cut my teeth in the disability rights movement. So many people that I care about and several groups have come to me in the past 36 hours of all of a sudden popular and expressed concern about what this bill means for students with disabilities, specifically the free and appropriate public education provision of the Individuals with Disabilities Education Act that governs special education in this country. And as a beneficiary of that law, obviously I care about it. And several of them asked me to offer an amendment, but I will not do that because, and this is totally sincere, I have enjoyed getting to know the chair for the past 2 years, and I know I've been so moved by his decency many times, and I know that he would not do anything to harm students with disabilities. And so what I will just say to my friends in the disability community is let's see how it pans out. And then, as I've told Mr. Marsh, if there's a problem in 2025, we will fix it. But I know the chair to care deeply about people with disabilities and to be a man of decency. So I will not be amending the bill today, and I'll be supporting it.
Delegate Pasteur.
Okay, thank you, Mr. Chair. I would like to go back to my question from this morning, and it was just addressed by the Vice Chair in terms of the animal cruelty. I guess I'm looking at, I'm looking for something that is real clear and definitive about what happens to those children. I've heard you say being detained, heard services, but I want to know, just based on the answer this morning, and I agree that it has often been, that behavior has often been tied to some very, very serious emotional and psychological issues. So I want to know what we will be doing through this bill directly, specifically to help these young folks. What, not just services, what clinically we are doing to support them. And that's the only detention I really want to hear about, how we're going to help them, please.
So again, I think there are different programs that depend on where they see the kid and what the kid's needs are. It's hard to say that there's one thing for every single child that could commit that crime. What the bill does is it addresses 10 to 12-year-olds who commit aggravated animal assault. It's a very small universe of people. I think it's 4 or 5 in the last 5 years that were covered by this. And so if you're asking me what very specific services they get, I cannot tell you what specific services they get. I do know that they would be under this bill, under DJS supervision, if they were adjudicated delinquent for that crime. They're not, if DJS decided not to go forward with the crime, then they wouldn't get services through DJS. But that would be a decision that DJS would have to make and would have to make going forward. So I don't have I will tell you, I can't answer a question on every single example and every single individual child. But that is the responsibility of DJS to figure out what services they need and to make sure that they get those services as part of being under their supervision.
Well, I understand that, and I certainly appreciate that, because we never should look at anyone, and particularly children, just through one lens. But I don't feel like it has always, what has happened to them is all, whether it's 4 or just 1, has been really working or what they needed. So I'm not feeling real comfortable that something different is going to happen now. I just want, which is a piece of why we have a commission, from which services are we drawing? And I'm not asking you for specifics, but I
I mean, the difference between what happens.
It's better than it's been in the past.
What the difference would be, just to be direct, the difference would be between the services that they may or may not get as part of the child in need of services, the SINS process, versus the services that they would be required to do under the Department of Juvenile Services. So it is a question, perhaps, that the services are being offered in one way they're being, in essence, they're being required to do them, as opposed to the SINS process where there isn't, there is the potential that somebody could simply walk away from those services with the parent's consent at the end. So that's more of the distinction, I think, than anything else.
Thank you.
All right. Members of the committee have been receiving just the overall changes that were made by the Senate, and there are changes that were made and that were the subject of negotiations between myself and the chairman of judicial proceedings, Senate President's office and the Speaker's office, as we dove in between the two bills that exist, the House bill and I think it's Senate Bill 744. So we went in and looked at those in detail and sought to work out the differences in these ways. Delegate Tolles.
Thank you, Mr. Chair. Now that I have a hard copy, because this is not ENT, this is judiciary, so it's always a lot of paper in court, right? So I needed to print it out to see just some of the questions I had. I know there was a lot of discussion. I know we mentioned it this morning, but I missed that part. Can you talk a little bit about the effective date? I know that was something that was important to this committee, what it was when we moved it and what it is now and why the change?
In the bill, the commission was to start on July 1st, 2024, and the changes in the substantive provisions would become effective on January 1st, 2025. What the amended bill says is that the commission would start on June 1st, 2024, and the changes in the substantive provisions would start on November 1st, 2024.
So are they turning this into an emergency bill?
It's
Or-
not an emergency bill.
Because normally we start
You can
July,
You can start in June. You can start June 1st.
and this is only for the commission.
I'm sorry?
This is only for the commission?
The
or
commission
entire-
would start on June 1st, yes.
And then everything else?
On November the
first.
1st.
And, okay. And you, and we feel that that's enough time for them to,
The commission is going to be acting, going forward, in perpetuity. Maybe not in perpetuity, but it's going to be going forward and year on year. This is not something that is just going to stop on November the 1st.
well, let me
It's gonna
clarify.
keep going.
I'm aware of that. I just wanted it on record that they're going to begin to do the work as early as possible. So I just wanted that.
My understanding is that this governor's office will seek to fill the commission and get that moving as soon as the bill is passed.
Okay. Thank you. I'm just trying to process everything.
All right,
Thank
I'll let you process and I'll go to Delegate Sample Hughes.
Thank you, Mr. Chair. I just want a clarification on a couple of things. I was reading the racial impact note for this particular bill, and I know it at the very onset, it references the 10 to 12 and minorities, youth being unfortunately the helm of the bill. But I guess my question is, when you reference that the 10 to 12 is taken out for the car theft, is that correct? Is that correct? Okay.
Yes, car theft would not for 10 to 12-year-olds would not be under DJS jurisdiction.
Okay, so is the 10 to 12 population affected in any other area of the bill as well, or that was just the main area?
It remains the same for 10 to 12-year-olds who are alleged to have committed a sex offense in the 3rd degree and aggravated animal abuse or assault.
So that stays the same.
For the possession of a firearm, instead, our bill would have had them go to a diversion program in an undefined diversion program, and we tried to figure out a way to define that better, and we came up short. So instead, we have said that they cannot be detained for a first-time violation of a gun possession charge.
Okay, and that's in this amendment.
Yes.
Okay. All right.
For a second time, they could theoretically be detained if.
So it's going to take the
instead-
first time for
First time
the
they
kid to do
could not
something.
be detained. They would not go to Cheltenham or Hickey or any place like that.
Wow. Okay. All right. Thank you on that one. My second part is with regards to the intake inquiry. So I'm just thinking about officer in the street. So if the officer suggests that this child needs to have services from DJS and DJS has the ability to say no, but then they
Yes.
have to then address it by 2 days or within 2 days?
So what the
Oh.
way the process would be is that the officer might ask for the juvenile to be detained. What the bill says is if they ask for the juvenile to be detained, but DJS says that they don't believe that they're going to go forward with a kid, let me take a step back. Officer asks for detention. DJS says, we're not going to exercise or we're not going to give you detention of the child. They then would have 2 days to decide whether they're going to exercise their jurisdiction over the child. So whether they're going to allow the case to go forward at all, they would have to make that decision within 2 days. So it's a two-step process. They're looking at whether the child should be detained pretrial. If it's a no, then they have to move faster to determine whether there's a charge there or not.
Okay, because that was what, originally 15 days? Or
There
no?
was, I think that's right. I think it was a 15-day period.
Okay. And then my last question, regarding the violation of electronic monitoring, it just summarizing, it pretty much says that, whenever there's a violation of that electronic monitoring, I think state's attorneys and the courts are supposed to be involved, but is there a time frame from when, there is a violation of the youth to this process starting that the state's attorney, and the courts get involved?
They would receive notification of that. The court would then make the decision as to whether or not something needed to happen related to the violation of electronic home monitoring. It would be providing notice to the other two parties.
Time frame on once
no
the
time
notification
frame.
is
Right.
made aware to action.
So the idea here is that they have to provide notice to them, and then I would say they would almost certainly look closer at what's going on next. And what happened to I mean, did they cut off the monitoring equipment, or did they walk too close to where they're not supposed to be and they just were traveling down the street?
Or did they commit a crime?
Or did they commit a crime and they cut? Well, the home monitoring system isn't necessarily going to tell whether they committed
Or at the
actual
scene of a
crime.
crime, let me say
Right. I
that.
mean, or are they at the scene of a crime? That's a different question
Sure.
too. But the idea is that those parties would be able to at least get notice.
Okay, all right, thank you. Thank you for those.
Delegate Grabber.
Thank you, Mr. Chair. So I've just been notified that this provision about child sex offenders, I'm glad we decided to keep that in the bill. However, if you followed this issue through the course of the session, there have been several bills about this issue. Thank you. One of the bill that left the Senate and really addressed this issue exclusively was Senate Bill 1145. And this issue in Senate Bill 1145 and elsewhere, they included language about making the issue a reportable offense, and they did so because it essentially that they needed it to be included in the reportable offenses provision so that they could use it to address the issue. So this just came to me at the last minute, and I wanted to see if maybe you could take a peek at this bill with maybe exploring.
I've looked at Senator Saling's bill,
Yeah.
And I've looked at it closely. The challenge with Senator Saling's bill is that it would run directly opposed to IDEA. It would run directly opposed because it says that because it orders the school systems, it makes it a shall as opposed to a may. The other challenge that it has is it kind of runs afoul of some of the other requirements that have to be met to educate kids. We crafted the language that is in the bill and connected it to the adult sex offender list. We did that in, I think it was 2021. And we crafted that with input from all of the parties involved so that we could make sure that there was an alternative for people who had been found guilty in that case of a sex offense, to make sure that that there were alternatives for them that were outside of a traditional setting that would still meet the requirements that have to be met to ensure that they receive the education that they're entitled to under the law. So what the bill's language has right now reflects that and just adds the juvenile, adds juveniles to that. And I certainly believe that addresses that larger issue. I had reviewed Senator Saling's bill, and I understand why. I think that there was a question of how do you connect the dots between the juvenile registry and
It's the issue we
it's only
discussed, yeah.
it's only available to law enforcement. But the reality is, if a juvenile is found to be delinquent of one of the sex offenses, that information is going to go to the schools. So that's going to go to the schools as a mandatory reporter. And because that's the case, that resolves that issue, and the language then puts them on notice that's what happens next. And again, to echo what Delegate Kaufman said a moment ago, if we have to come back and try and fix that, I think it certainly would be something that we would want to do, but we're trying to stay consistent with the language that was already agreed to in a previous bill.
Yeah, and I don't think the totality of the bill, his bill, is necessary, but I think they were concerned specifically about the criminal 3307, the charge of rape. It's not a mandatory report. It's not under the very limited list of reportable offenses. And I think that's specific, just that one
But I
line.
think that sex offense 1 is, which is effectively the same thing.
Do you know which law that is? If you're not
just-
amenable, I get it.
I haven't memorized every section of the code yet. Yeah, I know, it's shocking.
Would you be
but-
amenable to adding just that one crime? I mean, it's rape.
At this point, the motion before us is a motion to concur. I think that that it is addressed in the bill just as it was addressed in the previous bill in 2021.
I appreciate the consideration.
Thank you. Delegate Crutchfield.
Yes, thank you, Mr. Chair. As I was listening to everybody, I was wondering if it might make some sense to really kind of just describe, and I know you've done this in the past, Mr. Chair, but just maybe describing to people how a complaint is actually filed in the juvenile system. And I mean, I'm just talking about what would happen with the 10 to 12-year-olds with the specific crimes that have been added. For example, if you go with auto theft and say the complaint, an officer has found the person, and then what the next step is, and the fact of what happens next. I think that might just be helpful.
So,
Thank you.
So for car theft for 10 to 12-year-olds, they would have to go through the process of filing a sins petition. And as I understand the Senate amendments, it would be effectively a mandatory sins petition. And members of the committee know that I've expressed on multiple occasions that I'm not sure the distinction between a mandatory sins petition and actually sending somebody into DJS supervision in some ways. But having said that, they would have to go through the process to file that petition. In the other cases surrounding 10 to 12-year-olds, they would go through the process that they would use if they had any child who was alleged of a crime, whether they were 13 to 17. They would have to go through the process, go to DJS. If they were seeking detention or seeking DJS involvement, present the case to DJS, and then they take the next steps with regard to detention or with regard to consent.
I mean, that's the first step.
They would be correct.
That's what I guess I'm trying
I mean,
to
if they're adjudicated delinquent at the end of after they have the hearing, they're adjudicated delinquent in those cases. So speaking specifically to 10 to 12-year-olds, that's the end of the story with regard to if sort of the court case part of it, where they're adjudicated delinquent for third-degree sex offense, aggravated animal abuse, and for possession of a firearm. All right. We are on the motion to concur. I'm sorry? One moment. Okay, we're on the motion to concur. Delegate Taylor.
I do have one last question, and it has to do with the mandatory sins petition for a child when they steal a car. If it's found that, because I understand when the sins petition is filed, the child is removed from the home. Is that right? Not all the time? Okay. Okay. Yeah, I'm trying to catch up. I'm reading it now.
You're good.
So they're not necessarily removed from the home.
Not necessarily removed from the home, no.
But at this point, they're in the system, so to speak.
You could argue that when they were arrested for stealing a car, they were put into the system, yes.
But at this point, do they have an opportunity at all to go into a diversionary program?
So with the way the bill is drafted, they would go into a SINS program. They would go into SINS. And as we've discussed about SINS programs, at the end of the day, it becomes effectively a voluntary program as opposed to something that they're mandated to do. Having said that, the attempt of what the Senate has tried to do and what previous language in the House has tried to do is figure out a way to compel them to remain in the SINS program. My argument would be, well, that looks a little bit like an existing, that looks a little bit more like the delinquency program than anything else. Having said that, that's the distinction between the two. And I think that there is a legitimate attempt to try and figure out how to address those issues in the commission going forward, and to look closer at the SINS process and say, okay, what are we ultimately going to do with that? That issue, I think, is a larger issue that we're going to have to deal with separately from what is in this bill. Okay.
Yeah.
Delegate Tolles.
Mr. Chair, I had a question regarding the failure to complete informal adjustment. Could you tell me, I guess in your professional role, what does that mean when what could happen when all the cases are forwarded to the state's attorney?
It means that they were set up to go to a diversionary program. That was set out. The informal adjustment program or informal adjustment is a structured response that diverts the child. And if they fail to complete that, basically what it's saying is we're going to refer this case to the state's attorney to determine whether they want to file a further petition to go forward or not. So in other words, they have failed to do in the informal. This is what would happen on the back end if they don't complete the informal adjustment.
What would that mean for so if they don't complete this process, right? And that's why I said, in your professional view, what would happen? What do you see when, cases like this go to the state's attorney?
Well, the state's attorney would have to make a judgment as to whether or not they could go forward with the case or not. They would have to treat it as if the case had just come into them.
And each jurisdiction can kind of make their own.
They would be able to make their own judgments and decide whether or not they wanted to go forward or not.
Okay. I am gonna have explain my vote, but I'll wait till we're voting.
All right. There are further questions on the motion to concur? Seeing none, all in favor of the motion to concur, please raise your hands. The Vice Chair, Cardin, Sample Hughes, Embry, Tolles, Schmidt, Simmons, Boucher, Phillips, Tomlinson, Arakan, Simpson, Grammer, Moon, Valentine, Conaway, Kaufman, and Williams. All those opposed? Crutchfield, Pasteur, Roberson. And Taylor, I'm sorry. All right, the motion to concur has been adopted and the bill will go to the floor for the concurrence. All right, we're going to go now to the voting list. I don't own, or actually I have a couple more concurrences that we will be able to do given our record on concurrences from yesterday, who knows? House Bill 833. This is Delegate Williams' bill. Delegate Williams, I believe that the amendments are more or less technical and you don't object to the amendments to House Bill 833?
The amendments, I'm fine with the amendments. I would ask that we, I guess, I don't know,
Are you
amend.
moving to concur?
Moving to concur with the Senate amendments. It just adds a provision that basically if one of the parents is available to care for the child, that there is a presumption that the child would go with the other parent if they have joint custody, as opposed to the child going with the parent that is in the in-treatment drug facility. That's basically what the amendment does, so.
All right. There's a motion and a second to concur. Is there discussion on the motion to concur? Seeing none. All in favor of the motion to concur, please raise your hands. 2, 3, 4, 5, 6, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Gotcha, Scott. All right. Anybody opposed? All right. The motion to concur is adopted. House Bill 496. This is legislation from Delegate Shetty related to the definition of consent. It adds language to the bill with a reporting requirement from the Maryland Judiciary where they ask for information broken down related to the number of charges filed in the state for violations of 3303 through 3308, which are the sex offense sections of the criminal law article. I'm sorry. That is what it's basically a reporting requirement. Could I have a motion? The chair would ask for a motion to concur. There's a motion to concur and seconded. Is there any further conversation about the motion to concur? Seeing none, all in favor of the motion to concur, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Anybody opposed? 1. The motion to concur is adopted. Gonna have to phone a friend about House Bill 585, which was our fun and excitement from yesterday. And so I will get right to that just as soon as I can. All right. Senate Bill 118. I'm going to bounce around a little bit here, so bear with me, but I'm going to try and knock out some easier stuff, and then because time is going to start being short here. Senate Bill 118 is the Senate cross-file. We moved to send a conference committee to do Delegate Atterbury's bill. However, we have agreement on the language, I believe, or we're making an amendment, actually. Let me do that. There's an amendment on Senate Bill 118 that does the following. It just adds the language that was added to the interlock statute that basically says for every day that you have that you're on the interlock, when you first are put on the interlock, that counts towards your 180. So it adds that language to this, but it also includes in this the expungement provision that allows for DUIs for PBJ and a DUI to be expunged after 15 years. So that would be the sum and substance of this bill as amended. So I need a motion on the amendment and the second. All right. So now we're on. So effectively, the goal here was, I think, that we have an agreement on how these bills are going to look going forward. So we're sending this bill back to the Senate. So hopefully either this bill or Chair Atterbury's bill will make it across the line here in a couple days. Any discussion about this amendment? Seeing none. All in favor of this amendment, raise your hands. 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Anybody opposed? One. All right, the amendment's adopted. We're on the bill as amended. There's a motion for a favorable and a second. Is there any further discussion on Senate Bill 118 as amended? Delegate Valentine.
I did have one question just as a whole in these bills that we've looked at for the ignition interlock. And my question is, and I think I've got the answer. In the administrative portion for MVA, when an ignition interlock is in place, it's usually, or it has to be a 0.15 BAC or more. When you're under arrest, the MVA portion is when the ignition interlock goes into effect. If you take a breath test and it's over a 0.15. For the probation before judgment, if once you've gone through the criminal side or the adjudication, a PBJ is for any conviction under 21-902. It does not have to be over a 0.15. It could be, you could have been either a refusal or a 0.08, for example.
That's correct.
So there is a difference.
There is a difference, but there's also, if you choose not, you can choose to get the interlock and not be suspended. That's what you can use the interlock to avoid being suspended under 20 if you were effectively refused, if you refuse taking the breath test. So that's another way that you can get to the interlock on top of over a 0.15.
Okay.
Right. So in any case, what the legislation as amended would do is it would say from the day that you put the interlock on your car, that counts towards the 180 days that you would be required to do it under the law.
Thank you.
All right. Further discussion. Delegate Tomlinson.
Yeah, I had an amendment on this one.
You, okay.
I don't know where.
All right, why don't you describe what your amendment does?
Okay, thank you. My amendment, what it would do is change that. Instead of saying that you get that you have to have the interlock on a PBJ, regardless of what the driver blew, it would only apply if you blew a 0.15 and over. I know last year when this bill was tossed around, I know I had talked with many at the time, Vice Chairman Moon and yourself and different committee members about this. Because there is a difference between, I mean, it's already recognized that there is a difference between 0.08 and 0.14 versus over 0.15. And my concern is that the universe that is getting captured here by just saying that everybody over a 0.08, which obviously, you know, is the federal BAC level. I'm not sure if we're exactly capturing I mean, it's obviously not good to drink and drive, but I mean, this is capturing, you know, people who are on the lighter end, weight wise, you know, have 2 glasses of wine and they're easily over 0.08 versus, you know, the guy that's been at the bar for 6 hours, you know, throwing down drinks. And we're having them, you know, get this interlock. I mean, you know, with this bill, it's going to require that all these people have to get the interlock. And I don't know. I think it's a bridge too far. Don't get me wrong. I like the expungement. I like the expungement piece. I'm glad to see that was included. I like the expungement when it was a separate bill. Because I think that that's been needed for a long time. I mean, at this point, we're expunging a lot of crimes that were committed in the past, and DUIs have always been held to a different standard. So I like that part, but anyhow, and I know Delegate Valentine was kind of talking a little bit about the 0.15 and how it's already in law established to be different. So anyhow, that's the amendment, that we wouldn't be giving the interlock to everybody who gets a PBJ, just those who get a PBJ who blow over 0.15.
Right, is there a motion on the amendment? Are you moving the amendment? Is there a second? All right. So what you're saying is that, okay, so what the bill would do would be to require everybody who is convicted of either a DUI or a DWI, an A or B, A meaning, or whether you take the test and blow over a 0.08 or you're just driving while impaired. The bill as it stands would require everyone to get that, as opposed to just people who blow over a 0.15. And I can see where this goes back to the question that you were asking a moment ago, Delegate Valentine, where there is a distinction between people who, when they are arrested, or if they're over a 0.15, they automatically go into I believe into the interlock system, as opposed to the people who have to ask to get on the interlock in order to avoid having their driver's license suspended altogether. I think at this point, we've already, I mean, I guess the chair of Ways and Means' bill has already gone to, is going to a conference committee, or at least I haven't heard anything back yet from the Senate. We'll see if that actually gets appointed here shortly. This is sort of beyond the scope of what we had been talking about there. I kind of feel like this would almost act as, it's interesting. In arguing against this, I can make the argument that by setting a specific target to avoid, it would be, if they went over 0.15, they would be on the interlock. But so would that discourage people from taking the test, from taking the breath test, which then puts them into a different category altogether? And I believe, I mean, I think that the concerns of certainly the advocates, particularly from MAD, are that they want to make sure that they're catching those people. This was a whole part of a larger debate that the legislature had over the last almost 10 years, wanting to make sure that people who refuse the test and are convicted are actually on an interlock at some point, whether it was up till now with a conviction or not. So
wasn't trying to change that piece about refusing. If you I wasn't trying to mess with that at all. If you refuse, still get, yes, you still have to get the
so
interlock.
it would only be if you took the test and you were under a 0.15.
Correct.
I almost think that it would definitely encourage people. I mean, I guess then they would fall into the place where they would have to get, have to get an interlock. But at the same time, I would politely ask the committee to resist the amendment, because I think it adds a level of complexity to this that I'm not sure works. But you've made a motion and a second. We'll see if there's other discussion, and maybe prove me wrong here. Is there any other discussion with regard to the amendment? There's a motion for the previous question. Any objections to moving the previous question? Seeing none, we're on the amendment. All in favor of the amendment, raise your hands. This is on Tomlinson Amendment. 1, 2, 3. Anyone opposed? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. Amendment is not adopted. We're on the bill as amended. Any further discussion on the bill as amended? There's a motion and it's a second. Is there further discussion on the bill? Seeing none. The vice chair. Yes. Crutchfield. Yes. Cardin. Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. I'm saying yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. No. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. Yes. Moon. Yes. Valentine. No. Conaway. Yes. Kaufman. Yes. Williams. Yes. All right. We will send that to the floor. One moment, please. gotta deal with those issues here. All right, so
This one's ready.
which one?
I got that ready, if you want.
House Bill 188. House Bill 188. By the way, everyone, Patrick Burns is here, making sure that we're,
Glasses on.
yes,
Guy in the front row.
Patrick Burns is here. So everyone needs to try and behave. One moment, please. Okay, House Bill 188. This is legislation related to administrative charges that get filed by law enforcement agencies against police officers that is not required to be reviewed by an administrative charging committee. It would set a statute of limitations of a year and a day from the date of the incident that led to the investigation. There was further conversation. Do you have an interlineated copy of the amendments? I think they should have.
Send it out to everybody.
Just sent this out,
But if you just want to look at this.
right?
This
Does
is what
that
it-
reflect the, oh, okay, with the changes that you
Yeah.
made there, okay. So the concern that was expressed is that sometimes these charges could result in criminal charges, and so we wanted to make sure that the year and a day toll. So that they could get to those charges after the criminal process finished. And so what you see before you, I don't know what the amendment number is at this point. Do you have that? You should have just received this on 313 026. What the amendment would do would say that, and what we did is we took an amendment from that actually was recommended to us by the Police Accountability Board of Montgomery County that seeks to kind of balance this out. That except as provided in subsection E for an incident involving a member of the public and a police officer, the process of review by the investigating unit through disposition of the administrative charging committee shall be completed within a year and a day after the date that a complaint is filed by a member of the public or by the appropriate official employed by the law enforcement agency, but by the date that they became aware of the incident, whichever occurs later.
It conforms the bill to the way the Senate passed it.
And so it conforms the bill to the way that Senate Bill 608 was passed. It makes a change, a tweak that says that it's based on the date that a complaint is filed or the date that the appropriate official employed by the law enforcement agency became aware of the incident. This should take care of the concerns that were out there from the ACLU. It's something that the chiefs and sheriffs I know are okay with, and I believe that the Fraternal Order of Police are okay with it. And so, with the three legs of the stool intact, that is what the amendment would do. Is there just a motion for the amendment? Is there a second? All right. So now we're on the amendment. Are there questions about the amendment? Okay. Seeing no questions about the amendment. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21. Anybody opposed? All right, the amendment's adopted and we're on the bill as amended. Is there a motion? Motion for a favorable and a second. Any further discussion on the bill as amended? Seeing none. The vice chair.
Yes.
Yes. Crutchfield. Yes. Cardin. Yes. Sample Hughes. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes, Tomlinson. Yes, Erican. Yes, Taylor. Yes, Simpson. Yes, Grammer. Excused. Apparently is excused. Moon. Moon. Yes, Valentine. Yes, Conaway. Yes, Kaufman. Yes, and an add. Williams. Yes. Looking around, I don't see anybody else asking. All right, Conaway asks to add. I don't see anybody else. Okay. I'll pass that over to you for a moment. So 188 is, scratch that one off. One moment, please. Going to do House Bill 813. 813. Delegate Toll's bill. Oh boy. Okay, too many things, too many balls in the air. That's over there. $813, there it is. Don't believe there are there amendments to this? Yes, there are. 313320. And amendment number 1, Delegate Tolles, do you want to talk about what the amendments do, please?
Yes, thank you, Mr. Chair. Essentially, this amendment just conforms to what the Senate version is. They essentially are the same. It conforms to, believe, SB 139, and it makes it so that the obligor is it does not let me just read it. It does not apply to an obligor whose individual income for the current year is greater than 250% of the federal poverty line. It determines the most recent child support order that was entered, and it removes the comptroller or an employer of the obligor from the exceptions. I'm sorry, it removes information of the obligor's income provided by the obligor from basically removing the comptroller out of the whole mix of it. They sent the email and saying that they didn't really get into that portion of get into child support, so they wanted to just be removed from the bill. And it conforms to Senate Bill 139 and also removes the sunset as well. And I did want to also, if I could, Mr. Chair, add that the committee voted this bill out last year. Everyone in this committee, I did get the vote list, voted the same bill out. So this is essentially not a new bill. I've had this bill since last year, or actually I did not have the bill last year. Another delegate had it. I have it now. And so we're just I'm asking to move the same bill that we did last year. So I'll stop there. I added the amendments and extra commentary as well. So move the amendments.
May I ask the gentlelady from the 25th District a question, please?
Yes.
My question is, and we have to go to the floor in a little bit, so I'm happy to park it. But at some point, court's indulgence, if you will, it would be helpful to learn how your bill is different from the Simpson and Taylor bill. So I'm happy to park the question and support this bill, but I would love to know the answer to that so I can fully process what I'm voting on.
Okay, thank you. You voted for it last year. Yeah, okay, so it's no different. Okay, well, we can talk offline later if that's okay. Thank you.
Are there further questions on the amendment to 813? Seeing none, all in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? Amendments are adopted. We're on the bill as amended. Motion for a favorable and second. Any further discussion on House Bill 813? Seeing none, the vice chair. Yes. Crutchfield. Yes. Carden. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Simmons. Yes. Boucher. Yes. Phillips. Yes. Roberson. Yes. Tomlinson. Yes. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. Moon. Yes. Valentine. No. Conaway. Add on for Conaway. Yes. Kaufman. Yes, and an add-on for Kaufman. Williams.
Yes, and a Kaufman.
Yes, and a Kaufman. Anybody else? Phillips. Don't see anybody else. All right. That is 813. We'll go now to Senate Bill 139, which is the cross file, which I believe would then be clean. Okay, so there's no amendments. There's a motion for a favorable. So I will entertain a motion by unanimous consent to have the votes from House Bill, let me finish, House Bill 813 be the same votes on Senate Bill 139. Is there an objection? Seeing none, the same votes as were cast on 813 are the votes that are cast on Senate Bill 139. So that motion is adopted. All right, so now we're going to go to another delegate tolls bill, and we're going to go to the organized retail theft bill. We're going to do House Bill 948. All right, so we had this a long time ago, and the Senate did send over a bill. We're going to send over Delegate Tolls's bill. What the bill does is it takes the Senate bill and makes two further amendments. One is it puts into the bill that jurisdiction for these cases must occur in circuit court, can't occur in district court. And second, it amends the penalties provision so that it's not just 5 years. It reflects the existing theft statute that says it's 5 years for $1,500 of value to $25,000. Then it is 10 years for $25,000 to $100,000. Then it is 20 years for anything more than $100,000. One moment, please. So just to be clear, and just for the committee, because there is nothing that explicitly states that, because of the way that we're changing the penalties, it would automatically, I think that's, they're all felonies. Because they're all felonies, they would all go into circuit court jurisdiction anyway, and that's the way the bill came in, where they were all going to be felonies. So we're on the amendment. Can I have a motion on the amendment? Motion for favorable in a second. All right. Delegate Phillips, then Pasteur. All right, no, you're Pasteur. Oh my God, then Boucher.
It's I just want to, since I don't practice criminal law, but I want to make sure on the sentencing, I understand this correctly. What you described were the maximums for those. Thank you.
Correct. So the idea here is, and it was a question that I asked, maybe a little pointedly, that it didn't reflect the increase in value that we have already in the theft statute. So this would do that. We're going to send it back across the street and see what they think. Delegate Boucher.
Mr. Chairman, if someone does this stealing through Howard County, Carroll County, Frederick County, and it goes to circuit court, which one of the jurisdictions claims the original jurisdiction to try to
It
keep?
depend on what state's attorney's office decided to file. They would have to file an indictment and they would have to include the information from all the thefts.
So they
But they
pulled
would
it
have
from-
to work amongst each other to figure out who was going to actually bring the charge.
So there's no codification of that?
No,
All right.
because I'm not sure how you would, I don't want to,
All right,
yeah.
I got you.
I don't know how that would
That's
work.
their problem.
All right, Delegate Tolles, then Embry, then Cardin.
Thank you, Mr. Chair. I had wanted your thoughts. I had a recommendation from the state's attorney's office, similar to what happens in the attorney general's office when they take over a case to kind of sign off on it. The state's attorney is sign off on the fact that, hey, if something happened in Anne Arundel County and now it's in Howard County is going to take it. And they did have a crime in Anne Arundel, but they're signing off on it. Would that be something you would be friendly and open to?
Well, I think for right now, I think that we have to, I think that establishing the crime is fine. How the state's attorneys are going to choose to prosecute these cases, we can, I think we can defer to the state's attorneys as to how they want to do it. I don't want to necessarily codify exactly how that would work or whether, but I think the other problem that they have is if you had multiple jurisdictions who all put in the same set of charges for the same set of events, you're going to run into a problem where you're going to have double jeopardy issues all over the place. And so they're going to have to coordinate with each other
Right, and that's
to
the,
determine where that actually works.
and that's that was the thought behind it. Was that from a state's attorney who I conversed with has said that possibly it could be he indicated that it could be a double jeopardy issue, and I didn't want that to occur, but you don't believe.
No, I think they would want to avoid the double jeopardy issue. So yeah.
So automatically they would kind of work together in the sign of, okay, I'm going to take this. Maybe it was
Right,
the theft was higher, so I'm going to take it over here.
right.
Okay. All right.
Delegate Embry.
Thank you. I support everything. I just wanted to be clear. I didn't see the circuit court edition in the report.
So, right, because the charges are all felonies, they would
Okay.
they would have to go to circuit court.
Because they're not excluded.
So what
like
Claire
that.
told me is that she didn't actually need to write something, and then we talked about how appreciative she was of that. It took a while. Delegate Cardin.
Chair, I was gonna ask about the double jeopardy issue, but it sounds like that's something.
Yeah,
that
I mean,
they're
they'd
gonna-
have to avoid the double jeopardy issue. You couldn't bring these in multiple jurisdictions.
So if you
I mean,
have,
again, everybody, again, I think that they would have to coordinate with each other because you couldn't include a crime that was brought by another jurisdiction in a different place, especially if then they went
Right.
forward, you'd have to get rid of presumably that indictment for organized retail theft.
we're giving them the permission to be able to use an event that happened out of their jurisdiction as part of their evidence. I mean,
Yes.
is that explicit or is that implicit in this?
No, it's explicit. It says that they have to demonstrate that it's happened with the same people in multiple places as part of a continuing course. of
But I know
conduct.
this would never happen in Maryland, but if you had two state's attorneys, elected state's attorneys from two different jurisdictions who were competing to try and handle more prominent cases, that they could in fact impose on themselves a problem by choosing not to work together.
They could create a problem for themselves, but I think they'd look pretty dumb if they lost. Sorry, I think they would look less than smart if they decided that they were both going to bring the cases at the same time because they're both going to lose.
But
Or one of them is going to lose, and they're going to be kind of playing Russian roulette with this.
I'm very much supportive of this and hope that we
I
can
got it.
keep them playing nice in the sandbox.
Yeah. Best of luck. Delegate Phillips.
Yeah, if I could, Mr. Chair, we're going around about this. The States Attorneys Association indicated that they already have a plan, because I asked that question because it was concerning, that they already have a plan working together on how to address these prosecutions. Thank you, Mr. Chair.
That is what they've said. So hopefully it will avoid the major problems that could potentially happen with that. Delegate Williams.
I'm sorry. So now I'm a little curious about this plan here. So how, I don't know. I guess one of the concerns I've always had with this bill is about the state's attorneys forum shopping to choose a jurisdiction that they believe would be basically sort of tough on crime versus a jurisdiction that might not be perceived as tough on crime. And so this plan that they had, is it going to be based on this is where the majority of the offenses occurred, and so that's where we're going to adjudicate the case?
So I think there's a practical element to this where, and I was getting into this when I was asking some of the questions there, that to make these cases, you're going to need to be able to get the loss prevention people from those stores to show up. If you're asking them to go to a jurisdiction that's far away, the odds that they're going to show up start to drop. If a lot of the cases are in one jurisdiction, it's just going to make more sense from a practical perspective to do that and to have those cases tried in that place as opposed to moving them all over the place. And so I think there's a practical side to this where they're going to definitely choose their forum. But at the same time, they've got to be practical in how to try the cases, because I still think this is going to be hugely difficult to prosecute. I think it's going to be hugely difficult to prosecute. Delegate Tolles.
Thank you. And I did ask, I don't know if he's still the state's attorney for association, but as Delegate Phillips said, that, the State's Attorney Association is aware of this. And I do think it's important not to codify what jurisdiction does what. And then other states has also done this as well. And then we do have some guidelines, because the Attorney General's office often obviously coordinate with different jurisdictions as well. So, and they have a process in which they do that. So I just wanted to close that out there.
Are there any further questions about the amendments? All right, there was a motion and a second. All in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anybody opposed? There's a motion for a favorable now that we've passed that amendment. Any questions with regard to the bill as amended? Seeing none, the vice chair? Yes. Crutchfield? Yes. Carden? Yes. Embry? Yes. Pasteur? Yes. Tolles? Pasteur is an add. Tolles? Yes. And you put in the bill. Schmidt? Yes, an add for the work. Simmons? Schmimmons? Yes. Boucher? Yes. Phillips? Yes. Roberson? Yes. Phillips is an add. Tomlinson? Yeah. Yes, and an add. Erican? Yes, an add. Taylor? Yeah. Yes, and an add. Simpson? Yes. Grammer? Still not here. Moon? Yes. Valentine? Yes, and an add. Conaway? Yes. Kaufman? Yes, and an add. Williams? A yes, sort of. Okay. Carden is an add. All right, we are being called to the floor. We are definitely coming back tonight. I'm sorry. I tried, but all right, what's your pleasure? We can either come back tonight or we can. Okay, since people are shouting different things, all in favor of coming back tonight, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. All in favor of coming back tomorrow. 1, 2, 3, 4, 5. We're going to come back tonight after the second session. Thank you very much.